Ladies and gents, welcome back. While most people have been distracted with the inquiry into the use of the Emergencies Act, some other things have been happening as well. And one of those things was there was several cases that were going against the government for the travel mandate restrictions that had taken place for some time in Canada. And Brian Peckford had a case. I know Maxime Bernier had a case, and I think there was another one. So what happened there was when the restrictions were lifted, the government came in and said, "Well, hey, these cases, I know that you're coming after us for it, but we just want to claim this as moot. It's not even a thing anymore. So we're going to throw this case away." So there was a hearing on whether that was going to happen, and that happened just on Friday. As always, Friday news, they try to bury a story on a Friday afternoon. So we're bringing it here Tuesday morning so we can have it fresh in people's memory on exactly what's going on. And for that, I brought in Keith Wilson to talk about exactly what's happening. So what happened? Can you explain this story?
Sure. Well, I mean, just to come in at a high level and zoom down, we all know that the federal government almost 2 years ago brought in travel mandates that prevented over 6 million Canadians from their fundamental charter right under Section 6 of the Charter to travel. Prevented them, if they were unvaccinated, from getting on an airplane in the country, to leave the country, or to get on a train. And so Premier Peckford, being the last living signatory of our Charter of Rights and Freedoms, which is remarkable in its own right that we're blessed with that person still being alive.
And he would know a thing or two about what's in it.
Charter was.
Yeah, he would know exactly what's in it.
I kind of know what was. Yeah, and this is never in his wildest nightmare did he imagine that he and 6 million other Canadians would have that fundamental right taken away. So I became his lawyer along with a team of lawyers. And we brought a charter challenge seeking to strike down the federal travel mandate legislation or orders that were barring 6 million people from traveling to be with loved ones, to be at the side of a dying loved one, to go to a funeral, to be at the side of someone having their first grandchild and help with the transition of that, or being at special events, weddings and 50th anniversaries and so on. He just said, that's wrong. We got to challenge this. It turns out that two expats from Britain, Sean Ricard and Carl Harrison, had also brought a challenge, as well as Maxime Bernier and another fellow from Quebec. And so those four cases got consolidated into one. When the court's faced with a situation where you have almost identical cases, they're not going to hear four cases. They're going to consolidate them into one.
So does that make it like a class action? Is that how that works?
No, it's just an efficiency. It's just an efficiency. And the efficiency is, strategically, there's a tremendous advantage. And I had to initially convince the other lawyers to do it because they'd never done it before, okay. Which is, it meant that when Dr. Larenko, the head official at Health Canada that approved the experimental vaccines, it meant I got to cross-examine her, and Carl Harrison's lawyer got to cross-examine her, and Maxime Brenier's lawyer. So we get to tag team 4 times, right? So you get a lot of advantages. In any event, so we brought that. We worked very hard on that case. The government presented 16 expert witnesses. Of course, as some have heard me explain before, when we'd hear the Prime Minister and the various ministers stand up, last spring, saying, "Oh, we're following the advice of our experts and our officials," and the next morning we'd be cross-examining those officials, and we'd say, "Well, did you give that advice to the Prime Minister?" "Oh, no, it wasn't me. So, it became pretty clear that this was just political, and the Prime Minister was using it to further his insidious policy of politics of division and trying to create hate within our country. In any event, in June of this year, the federal government ministers finally announced, because we were the last holdout, that they were going to suspend these travel mandates. And because of that, the federal government lawyers, the Attorney General, brought an application to the federal court and said, "Hey, these rules are no longer in place. They've been suspended. So there's nothing, Mr. Peckford has his rights back. So there's nothing for the court to rule on." And it's called a mootness application. So they applied to have our our charter challenge struck out, put to an end, killed on the basis that it was moot, that Mr. Peckford's rights had been restored along with 6 other million Canadians. So there's nothing for the court to rule on. We said, no, the case has to go ahead because all Canadians need to know whether or not their Charter of Rights and Freedoms mean anything.
Mm-hmm.
Does it mean anything? Because it's feeling right now like it actually doesn't mean anything.
Right.
When you look at all the government overreach. So they brought an application, the federal government did, their lawyers, to say, no, the case cannot go ahead. The court cannot rule on whether the charter was violated, whether the government went too far. It needs to be struck out. We said, no, when you look at the legal tests, this is a proper case for the court to hear. And last week we got the ruling from the court saying they're agreeing with the federal government, it's moot, and they've struck out our case.
So, I mean, that's obviously a tragedy right there. That's tragic to hear that was the ruling. Now, what most people don't understand about this whole concept is that the government didn't go through the legislature. They didn't legislate these rules into existence. It wasn't voted on in Parliament. It didn't get voted on by senators. This was some sort of decree or ministerial decree. How would you define that in law?
Well, you're correct. It was an interim order. So I can explain this. Mm-hmm. Think back to the 9/11 terrorist attacks. And, governments had to move extremely quickly, like to close the airspace, right? For example, when that tragedy happened in the United States with the attacks against the Twin Towers and Pentagon and so on. Mm-hmm. So after that, they amended our Aeronautics Act to give the minister and his deputy, the deputy minister as well, the power to make these emergency orders that would only be in place for 14 days if there was an urgent matter of aviation safety. So that's the provision that they used in COVID, never intended for this. And they said, this is an urgent matter of aviation safety. We are going to prohibit and make it illegal for unvaccinated Canadians to travel by train and plane. And we're using this interim order that was signed by the minister. He could literally be on the golf course and sign it. His deputy could be literally out having a steak dinner and a glass of wine and sign it and strip you of your fundamental charter rights. And this is one of the points we made in the mootness argument before the court. And it's this: in a democracy and a civil society, we have a 3-legged stool. We have the legislative branch of government, we have the executive branch of government, and then we have the judicial branch of government. And they're all supposed to keep one another in check, right? The checks and balances. As I pointed out to the court, this was not a measure. The stripping of 6 million Canadians of their fundamental charter rights was not debated in the Parliament. Didn't go for first reading and second reading, committee of the whole, third reading, royal assent, all that nonsense. Important dialogue of opposition, challenge, and so on. It was done wherever the minister happened to be, if he was at the golf course or at a ribbon signing or cutting ceremony for a new airport. And he didn't even have to go to cabinet. He could just do it on his own. And so we didn't have the check and balance of the Parliament. And the only recourse for Canadians to know whether or not their charter rights have been invalidated or violated is to go to the federal court. And that's what we did. And so I said to her, if you strike this down without hearing it on its merits and dismiss it for mootness, it will bring instability. A 2-legged stool doesn't stand up very well. And if Canadians can't come to the courts to get rulings on whether or not their rights have been violated, 6 million Canadians, then what does that do to the stability of our civil society? And what does that mean for our democracy?
Well, most people...
I hope to get through to the judge. I obviously failed. So our next step is to appeal. Premier Peckford has instructed that we're to bring an expedited appeal. We are appealing the decision to strike out this charter case. We will be appealing it to the Federal Court of Appeal. If we're successful, if we're not successful, then we'll appeal that decision to the Supreme Court of Canada. If we are successful at the Federal Court of Appeal, it will go back to the federal court, and they'll actually go ahead with the Mootness, or go ahead with the 5-day hearing on the merits of the case to review all the evidence on whether or not the vaccine was experimental, on whether or not it was demonstrably justified in a free democratic society to restrict the rights because of COVID, and so on. So we're just going to keep fighting. The reality is, I have been an optimist about our courts. I've been criticized by other lawyers for being an optimist. I've told them that I'm going to keep bringing cases to the courts, because one of two things is going to happen. Either I'm going to be proved right and that it's a worthy institution and that it's going to be doing its job of being a check and balance, or the cynics are going to be proved to be right, which is the institutions become corrupt. You know, there's this image of Lady Justice with the blindfold and holding the scales.
Yeah, we all know that.
The blindfold feels like it's right about down here right now. It seems to be more of a mask, you know, than a blindfold. I cannot come away when I look at all of the decisions from the various courts in Canada where they've all refused to examine the evidence for and against these COVID mandates. They've refused to examine the evidence about the ineffectiveness of masks. They've refused to look at the evidence of the overwhelming negative adverse effects from vaccine, myocarditis, and all of these other things that are well established now. They've refused to look at the ineffectiveness of the vaccine that has not prevented any transmission whatsoever, that it is experimental. They did not do phase 3 human trials. It's occurring right now on over 30 million Canadians, and they were not asked to consent to that. So this is serious stuff. We're going to keep going.
Well, I know I can't make any of those claims myself because I'm the one hosting this channel, and there's rules on YouTube about what you can and can not say. But I'm glad to hear that there's hope in the higher courts that we can have this appealed and move forward with some justice. Because I mean, the hyperbole here would be to say that we're living in a dictatorship. But when you see rules like this come into play that have so much effect on everyone's lives by dictate, I mean, what else can you call it? So that's kind of where we're here. I want to thank you so much, Keith, for coming in and talking to us about this today, because we need to get this news out there to as many people as possible.
Thanks for having me on, Clyde. I really appreciate the opportunity.
Cheers. And I want to thank you guys for tuning in and staying in touch and in tune with what's happening around Canada. I know that a lot of people are wrapped up in the Emergencies Act inquiry at the moment, which is not really going so great for the government if you're actually looking at the evidence and the reason for the inquiry. But I'll definitely keep you up to date with that and other stories going on around Canada. So thanks for all tuning in, and hit that like button. Let the algorithmic gods know what to do with the video, and we'll see you guys in the next one. Keep on trucking.